over a decision handed down by the U.S. Supreme Court today.
The court ruled that police officers who fail to read suspects their Miranda rights can't be sued. Joe Dana explains the potential fallout.
The power of police to interrogate a suspect is enormous. The Miranda warning is intended to protect suspects from being unfairly treated. Today's decision weakens that protection.
Constitutional protections for the accused.
Cops can introduce coerced statements from you, which may or may not be used against you, which may or may not lead to your conviction, but regardless of outcome, whether you're guilty or not, you cannot sue them for damages after the fact. We've taken accountability off of the table. So hi, what can I do to protect myself? Well, as my friend and favorite public defender, Eliza Orlins, would say,
do not talk to the cops, ask for a lawyer, and then shut the up.
Police officers can get in big trouble if they arrest someone without reading them their Miranda rights.
The 1963 arrest of a man in Phoenix led to a landmark Supreme Court ruling that is a household phrase. Police are required to tell suspects in custody of their Miranda rights, notifying them of their right to remain silent and their right to speak with an attorney. On Thursday, the Supreme Court ruled suspects who are not notified of their Miranda rights do not have the option to sue police for damages later.
It is another consistent.
Stewart says the decision by the Supreme Court is based in good faith and is a
minority who abuse these.
The most completely wrong opinion. The federal statute that gives you constitutional rights are violated and harms you. You ought to.
Officers can be sued in civil court, often forcing departments to pay huge settlements to those whose rights have been violated. At least that used to be true. Under the Vega decision, Americans can no longer sue police for violating their Miranda rights. And it won't stop there. Let's get one thing perfectly clear. Conservatives hate the Miranda decision. They claim it took power away from police, who feel they should be able to question suspects indefinitely without a lawyer present. And Supreme Court Justices Clarence Thomas and Samuel Alito see Miranda as fundamentally flawed in the same way Roe was, even if they can't quite explain why. With the GOP's new conservative supermajority.
Okay, so we're talking about Vega v. Tokah, and this is a 2022 decision, and this is about the Supreme Court. And there are some huge consequences. There's going to be huge consequences to this. And so let's read some of the background here. In March 2014, the LA County Sheriff's Department Deputy Carlos Vega responded to a 911 call related to allegations that a Terrence Tokah, an employee at the hospital, had sexually assaulted a patient. And so Tokah is going to confess to the sexual assault shortly after Vega had met him. He was tried on the sexual assault allegations but was acquitted. So how did that happen? He confessed, and yet when the trial happens, he's acquitted, so the jury didn't see any wrongdoing, even though there's a confession. Now, the Miranda rights, he's going to say he wasn't read his Miranda rights, filed in 1983, civil rights filing in federal court. And he was saying he was violated his rights under Miranda v. Arizona because the police officer, Carlos Vega, didn't read Terrence Tokah the Miranda rights. You have a right to remain silent. Anything you do say can be held against you. In a court of law, you have a right to an attorney, and if you don't have one will be provided to you. And that's important. That's very important. That's actually going to change the entire policing. When that Miranda decision was passed, what was it, back in the 60s? My God, this is like overturning precedent. Then Alito go on and on about stare decisis, 1966. So this precedent has been around for nearly over 50 years. So you're supposed to read the person their Miranda rights. And by telling them that they have a right to remain silent, once you tell them that, and then once you tell them that they have a right to an attorney, they can choose not to talk to you. That's the Fifth Amendment, that's the Sixth Amendment. So they're telling you that you are an American and you have rights and freedoms. And so this is important for several reasons. Like he said with Dobbs. Dobbs says that there's no right to an abortion in the Constitution. Specifically, there is no right to an abortion in the Constitution. There also isn't immunity. Immunity is nowhere in the Constitution. The right to get married is also not in the Constitution. So if you take away the right to an abortion, well, you're going to take away the right to get married. You're also going to take away the right to have immunity. In fact, there's 18 freedoms that I wrote down here, and then there's constitutional freedoms. So the biggest important thing for me is if they're going to get rid of Dobbs, if they're going to get rid of abortion, if they're going to get rid of the Miranda, saying the Miranda rights, reading, what other fiat freedoms is the Supreme Court going to take away? The right to reside with one's relatives. That seems like common sense to me. That's 1977 Moore v. East Cleveland. The right to marry comes from Loving v. Virginia, Obergefell v. Hodges, and Turner v. Safly. 1987, the right to use contraception in sacred marital bedrooms. 1965, Griswold v. Connecticut. Which one of these are they going to take? Are they going to say we don't have a right to condoms? We don't have a right to sacred marital bedrooms? So that's going to infringe upon the privacy within the home. The right to marry, if we don't have a right to marry, well then where does the right to marry come from? If it's not in the Constitution, is that common law? Was there something about the natural law? These seem like very obvious, and in fact, because the Supreme Court has, figured these out, it almost seems like these should be amendments. We should have a right to reside with one's relatives. There was a damn law that said that the grandson wasn't allowed to live with the grandmother. What kind of stupid-ass law is that? And the right to marry in the family, the foundational political unit. Don't you need people to get married? The right to decide one's child's education. Isn't that an important freedom? 1925, Pierce v. Society of Sisters. 1923, Meyer v. Nebraska. The right to not be sterilized without your consent. That seems like an obvious one, too. 1942, Skinner v. Oklahoma. Hey, no, I don't want you to go. No, I don't want that. That is the right for two consenting adults to have sex in the privacy of their own home. That's kind of like Griswold. The right to self-defense. Well, that's D.C. v. Heller. It's also the 9th Amendment. The right to self-defense is also Hobbes's #1 law when it comes to the state of nature. Are we going to throw away the right to self-defense? We're throwing away Miranda. We're throwing away abortion. What else are we going to throw away? There's the exclusionary rule, 1961 Mapp v. Ohio, and 1914 Weeks decision. So they bust down the doors in this lady's name Mapp, and they search through her stuff and they find pornography. Well, that's illegal. We didn't have a reason to knock down your door, but now we found pornography. And then the Weeks decision was they went into the guy's desk and they took papers off of his own desk. Well, you have a right to not to incriminate yourself. So the evidence that they took by the fruit was poisoned. And if it was got by illegal means, then that means the exclusionary rule means you can't admit it into evidence. You can't admit that pornography. You didn't think she had pornography. You had no reason to think that she had. It was in the bottom of her closet you don't even know if she was even looking at it. It could have been the people that was there beforehand. Unanimous jury notes. When a jury comes down to make a decision, shouldn't it be all 12? Well, hell, that's 2020. 2020 Ramos versus Louisiana. So is that Alito? Did Alito agree with that? So that's a brand new freedom created by the Supreme Court. Until we get even more conservative justices, then they'll throw that out. The right to securities of one's home. That's 1886 Boyd v. U.S. The right to expressive association. 1958 NAACP v. Alabama. 1984 Roberts v. U.S. Jaycees. The right to refuse surgery or forced administration of drugs. No, you're going to take these drugs whether you like it or not. I'm going to force you to take these damn drugs. That's not American. You can't force people to take drugs. Hell, we got a war on drugs. So sometimes people can force us to take drugs. Other times they tell us that we can't even take the drugs that we want to take. What the hell's going on here? I thought this was a free country. So all these freedoms come from different Supreme Court cases. And if they're going to throw away abortion and they're going to throw away Miranda, are they going to throw away self-defense? Are they going to throw away the exclusionary rule? Are they going to throw away the right to not be sterilized? You also have the right to reject life-saving medical treatment, 1990 Cruzen v. Director. The right to have children, 1942 Skinner v. Oklahoma. The right to the privacies of life, 1886 Boyd v. U.S. The right to a Miranda warning, 1966 Miranda v. Arizona. And the right to privacy, 1961 Mapp v. Ohio. So let's talk a little bit about this Vega v. Tokah. So Vega v. Tokah, 2022, they're going to just say that Tokah didn't need to be read his Miranda rights. And in a way, he doesn't need to he confessed to the thing. He got away with it in a fucking jury trial. So it's almost like, does the absence of a conviction demonstrate innocence? I don't think so. Oh, you didn't convict the person that was clearly guilty? And then it wasn't just sexual assault. I heard it was sexual penetration. He wrote some kind of apology note for inappropriate touching, but he didn't claim that there was any crime. Well, which is it? So the absence of conviction, that doesn't demonstrate innocence, just like a jury verdict in a kangaroo court doesn't demonstrate guilt. So the patient, it sounds like to me that Vega was right and Tokah was wrong. And so in a way, the Supreme Court, that should matter. So the Supreme Court wasn't just being exactly perfect. They were kind of saying, let justice prevail. Let justice prevail. This asshole sexually assaulted this other people. He wasn't read his Miranda rights. Now he's going to sue. Now he's going to get himself a fat $1 million paycheck. Well, that's not right. Now, if we presume that Tokah was innocent, that he just had trumped up charges and it was totally bullshit, well, you should be read your Miranda rights. That's important. The holding said that he wasn't in custody when he confessed to the thing. So therefore, they didn't have to read the Miranda rights. It's not until you're in custody. But then ultimately, he's going to be acquitted. Established injustice requires that the guilty pay for their crimes and for the innocent to be let alone. So let's get a Miranda case in there where you have, the Tokah, the other person, he isn't guilty. Let's have a person that's innocent. You have an innocent person, and then he starts saying this and saying that, and then he says something about having pornography, with the MAP decision. What's the other one? Weeks decision. So he breaks these other Supreme Court justice, things, and then they go after him for some other bullshit. Some other minor shit that doesn't even fucking matter. Oh, he's got marijuana. Half the damn country has legalized marijuana. But we're going to sit there and try to say that you're the devil, Hitler incarnate, because you got some people have marijuana and that's totally wrong. Meanwhile, people have acres and acres of marijuana and that's somehow totally okay. They keep using the word prophylactic measures. And what do they say? That's prophylactic is medicine or a course of action which prevents the spread of disease. So if you have a pandemic or a plandemic, there's airborne AIDS all over the place. Well, if you want a preventive measure to ward off what? The amounts of freedoms or the guilty people going free? Which is it? If we want the guilty people to be thrown in jail and we want to maintain our rights as a free country, I think we can do both of these things. So it kind of seems like Alito is leaning towards taking the Miranda rights away from us. All that talk about stare decisis at the confirmation hearing. He went on and on about stare decisis at the confirmation hearing. I want to mention another Supreme Court case, 1989, DeShaney versus Winnebago. Winnebago is a racist term meaning the stinking people. It's the Ho-Chunks. Winnebago County should change their name to the Ho-Chunk County. But DeShaney was a shitty-ass father, beat up his son Joshua till he goes retarded. He's 4 years old, gets hit too hard, and then he's going to be retarded until he's 36 years old, and then he's going to die at 36. So because the child services and the police and some other people, psychologists and hospital people, a lot of officials knew that the father to Joshua DeShaney was a piece of shit and that he was abusing him. And then his abusive father hits Josh one time too hard, makes him retarded. And so, is that okay? Is that acceptable? They're saying we don't have positive freedoms, we have negative freedoms, meaning you can prevent the state from doing shit, but that doesn't mean you have any affirmative. Equal protection means you're equally protected. So you're going to tell me that you could smack some people around all the live long day, and you could smack them until they go retarded, and then you can't get justice, you can't file any criminal charges, and you can't sue them? Poor Joshua indeed. Poor Joshua indeed. Now, not only are we being taken away these freedoms, there's a lot of freedoms in the Constitution that aren't even being respected. So let's presume that we're going to be originalist, we're going to be textualist, we're going to strictly read the Constitution. It means what it says and it says what it means. And if we are unclear, then we go to the original sources, we go to the Federalist Papers, we go to the common law, we go to natural law, we go to the Declaration of Independence, we go to the spirit of the Constitution. That means the Constitution says what it means and it means what it says. Well, the 7th Amendment says if there's any controversy that's over $20, you get a civil jury trial. No, the guy stole $21 away from me, and since he stole $21, I want a jury trial. That's what the 7th Amendment says. That's right there in the Constitution. So it would be progressive. I want all these freedoms, but let's say we get rid of all the SCOTUS-created fiat freedoms and we exchange them for constitutional freedoms. We're going to have people that's actually reading the Constitution for once in their damn lives. And we're going to get a right to a contract. We're going to get a right to a post office box. We're going to get freedom from bills of attainder, right to a jury trial in all criminal cases, the right to habeas corpus, freedom from ex post facto laws, the right to travel between the states. You know who said that? That was Scalia. The Scalia says we have a right to travel between the states. Where does it come from? It comes from the Constitution. Article 4, Section 2, Clause 1 says that the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. It may be esteemed that the basis of the Union that the citizens of each state shall be entitled to all the privileges and immunities of citizens of the several states. That comes from Federalist number 80. The right to rights not mentioned. The 9th Amendment says that we have a right to the, self-defense and other rights that haven't been put into this. 1983 goes from the 14th Amendment. They use a due process substantial freedom clause, and they have this crazy elaborate use the 9th Amendment. The 9th Amendment says we got all these freedoms, but we also have freedoms that haven't been mentioned. So let's pass an amendment. Let's have a constitutional convention. The 9th Amendment definitely says you should not throw away some of these freedoms. Well, which freedoms are that? I say let's elect self-defense. Self-defense is our 9th Amendment freedom. At the very least, that's one freedom, but I'm sure there's a bunch of freedoms that they mentioned. We also have a right to the powers of the federal government doesn't have. That's the 10th Amendment. The right to vote. That's the 19th, 15th, and the 26th, 24th Amendment. Freedom from slavery or involuntary servitude. That's 13th Amendment. Freedom of due process and equal protection in life and immunities and property. 14th Amendment. The right to birthright citizenship. 14th Amendment. The right to alcohol. 21st Amendment. Freedom from two-term presidencies. Oh, you want to stay in there for a third term? 25th Amendment says, go fuck yourself. Freedom from Congress giving themselves a raise. That's the 27th Amendment. The grand jury indictment clause. Nobody can put a felony on you unless you had 12 members of the grand jury and 12 members of the petite jury putting that felony on you. There's also the 3rd Amendment, freedom from quartering soldiers, and the 7th Amendment, the right to a jury trial for civil matters over $20. So when it comes to freedoms, let's go ahead. They're going to try to say there's originalism, there's no right to an abortion, no right to Miranda, because it's not in the text. Well, there's no right to marry, and there's also no right to immunity either. So we're going to get rid of immunity, so that's exciting, right? We're going to get rid of marriage, which is a little nerve-wracking. Maybe we should pass an amendment saying we have a right to get married, and we have these rights, and we like these rights. We should pass a couple amendments. Let's get another 10 bills of rights. It's supposed to be a free country, but the last time we passed a Bill of Rights was 1791. That's 300-something years ago. How come the last time we're supposed to be a free country, but we only passed a Bill of Rights one fucking time? So, Vega v. Tokah, 2022 is alarming. It could be something for, it could be greater. It could be saying that there is no Miranda rights. It seems to be slipping. And not just those freedoms, but more freedoms. But if they're going to throw away all the fiat SCOTUS made freedoms, are they at least going to heed the Constitution? Not like Alito to heed the Constitution when it comes to the 7th and the 3rd and the 5th Amendments. All the amendments, not just Amendment 1 through 8, but 9 through 27. Plus the body of the Constitution has freedoms, and the preamble's got freedoms as well. One of the end objects of the whole American experiment, we're supposed to establish justice, general welfare, domestic tranquility, protect the blessings of liberty for ourselves and posterity. So that's why you want to learn the law. Do you want to be a free people? Then learn the fucking law. Learn the law because those are the freedoms that you got. And you only get those freedoms. Once they're taken away, you'll never get them again. So, yeah, it seems like Vega v. Tokah. Tokah was kind of a piece of shit, right? So maybe you're just supposed to not read Miranda rights to pieces of shit. And especially pieces of shit that get away with it at the jury trial. So, Miranda rights for a piece of shit that got away with this bullshit at the fucking goddamn bullshit jury trial. Clearly something happened in that jury trial. Maybe he just had a shyster for a lawyer, a high-dollar lawyer that pulled some shit and got it thrown out on a technicality or some shit. So, yeah, when it comes to the DeShaney v. Waco, the Winnebago, what the cops aren't supposed to do any damn thing. They're only supposed to goddamn fuck with us and fuck with us and fuck with us. I like the Miranda decision, but if we're going to throw away the Miranda decision, then I'd like to at least get the freedoms that's in the Constitution. If we're not even getting the freedoms in the Constitution, well, shit. Then it's time for revolution, isn't it? And we're not even getting the freedoms that's promised to us in our own. That's a document. That's a contract. Is that not a contract, the Constitution?